Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip. Just been, there we go. Kathleen Zellner has posted on, oh my god, this is going to be long. Has posted on her website her response to the state's response to her stay in remand. So, and I didn't even put my frickin' iPad up in its stand like I do to try to make this look kind of better. And I have to try and read this now on my phone, and it is 56 pages. Literally just got this now, so I have not read it, so I don't know what's in it. So you're going to be hearing it as I do. And if you want to read it for yourself, you go to KathleenTZellner.com, go to her section for her page for Stephen Avery, and the link will be right in there. And we'll get that posted at some time. All right. Defendant appellant's reply to the state's response to motion to stay, appeal, and remand. The defendant appellant, Stephen Avery, by his undersigned attorneys, Kathleen T. Zellner and Stephen G. Richards, for his reply to the state's response in opposition to his motion to stay the appeal and remand the cause to the circuit court, states as follows. Introduction. It is a supreme irony that in one of the most blatant examples of a wrongful conviction, the state's only response is to falsely accuse Mr. Avery's... Oh, there's the clerk responding to me. I had emailed the clerk saying I wanted this, but now I don't need to buy it from them. State's only response is to falsely accuse Mr. Avery's lead counsel of nefarious conduct for discovering a sixth Brady violation. Rather than seeking justice, the state wants to slay the messenger by putting forth more false allegations, a skill that it has mastered over the last 16 years. The state turns a blind eye towards its past actions of withholding exculpatory evidence. When the state disclosed a CD of violent porn from the Dassey Yonda computer 12 years after the CD was created, and now Kathleen just tweeted, I just get notification on that too, so I can't do the Twitter thing right now, but know that she just tweeted. And concealed from prior counsel, the state argued, as it does now, that Mr. Avery was attempting to add new material to his 974.06 motion. When the state facilitated the destruction in 2011 of evidence it had agreed to allow Mr. Avery to test, the state argued, as it does now, that Mr. Avery was attempting to add new material to his motion. The court, that was one of my moderators saying KZ has responded. Sorry, I'm getting distracted. The state argued, as it does now, that Mr. Avery was attempting to add new material to his motion. This court did not accept those disingenuous responses then, and it should reject the same disingenuous response now. Sorry, it's hard for me to read and I've got a lisp. The state asked the court to overlook the fact that in further violation of discovery, it failed to disclose to Mr. Avery's prior counsel that a former driver who delivered newspapers to the Avery salvage yard in November of 2005 observed two men, including a shirtless Bobby Dassey, the state's primary witness in securing Mr. Avery's conviction, pushing Ms. Halbach's RAV4 down Avery Road prior to its later discovery on the Avery property. In its response, the state states, quote, "It is reasonable to conclude at this point that Mr. Avery is not pursuing these claims in good faith," unquote. However, the state's conclusion is clearly refuted by the procedural history of this case, the veracity of Mr. Sowinski's statements, the supporting affidavits, and the state's history of misconduct. While the state has not been prejudiced in any way by its own misconduct at this court's prior rulings granting Mr. Avery's motion to remand, its response merely mimics its previous responses to Mr. Avery's motions, arguing that Mr. Avery is, quote, "dragging this appeal out," unquote, and that he should voluntarily dismiss his pending appeal. It is the state's pattern of concealing and withholding exculpatory evidence that has forced Mr. Avery to delay his appeal numerous times already, delaying his quest for a new trial and eventual freedom. Argument 1. The state's argument that Avery did not conduct a reasonable investigation before filing this motion is completely meritless. The state argues, all of a sudden it was going off the page. The state argues that Avery's counsel violated Wisconsin statute blah blah by not conducting affirmative investigation into the assertions made by Mr. Sowinski in his affidavit before filing the motion for remand. Without citing any precedent or acknowledging Mr. Avery's prior discovery requests, the state suggests that Avery was required to attempt a new open records request to verify Mr. Sowinski's call and or ascertain the identity of the female officer with whom Mr. Sowinski spoke prior to filing the motion. The state maintains that Avery's counsel may not, quote, "rely simply on the word of a person like Sowinski," unquote, before presenting Mr. Sowinski's affidavit to the court. The state's argument should be rejected because it is based on a false premise, i.e., that Mr. Avery's attorney did not conduct a reasonable investigation into Mr. Sowinski and the averments in his affidavit before filing the motion for remand. The state's argument appears to be based on its self-serving conclusion that Mr. Avery's counsel stumbled upon Mr. Sowinski and within 24 hours filed the pending motion to stay the appeal and remand for Mr. Avery to file a supplemental post-conviction motion with the circuit court. And there's a footnote at the bottom of this page that says, ironically, the state does not describe what investigation it conducted to support its assertion that Avery's attorney did not investigate Mr. Sowinski or the averments made in his affidavit before filing its response in opposition to the pending motion. The state's conclusion is demonstrably false and the result of a careless, sloppy reading of Mr. Avery's motion. The simple truth is that Mr. Avery's counsel conducted a thorough investigation relative to Mr. Sowinski. Certainly, a great deal more effort was made to vet Mr. Sowinski than the state made to vet its primary witness, Bobby, who has been caught in numerous untruths. During Mr. Avery's trial, Bobby testified that he was asleep and woke up around 2:30 p.m. and looked out of the kitchen window of the Dassey-Yanda residence and that he saw Ms. Halbach's RAV4 pull up, Ms. Halbach exit the vehicle, and start taking pictures of the Dassey-Yanda van. When Ms. Halbach finished photographing the van, Bobby claimed to see her, quote, "walking up towards Uncle Steve's trailer," unquote. Bobby testified that he took a shower, and when he left the property at about 2:45 p.m. to go bow hunting, he claimed that Ms. Halbach's RAV4 was still on the property, but he did not see her. Bobby's testimony was the only evidence presented by the state that the RAV4 never left the Avery property after October 31, 2005. Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Ms. Halbach never left the Avery property. Based upon Bobby's testimony, the state claimed that Mr. Avery was the last person to see Ms. Halbach alive. However, Bobby's testimony is replete with lies and contradicted by numerous witnesses, including his own brother Brian, who told law enforcement that Bobby saw Ms. Halbach leave the Avery property on October 31, 2005. The CD, which the state withheld from Mr. Avery's counsel, also establishes a timeline of internet searches directly contradicting Bobby's trial testimony that on October 31 he was asleep from 6:30 a.m. to 2:30 p.m. Additionally, Bobby's testimony that his back was scratched by his puppy has been refuted by Mr. Avery's expert, Larry Blum, MD. Unlike the state's failure to investigate the credibility of its primary witness, Bobby, Mr. Avery's counsel rigorously investigated Mr. Sawinski's claims. Mr. Sawinski first emailed Mr. Avery's counsel's law firm on December 26, 2020. And Mr. Avery's counsel and her investigators vetted the legitimacy and veracity of the information provided by Mr. Sawinski over the next 3.5 months before filing the pending motion to stay. Prior to filing the motion, Mr. Avery's counsel, 1. Reviewed Mr. Sawinski's email sent on December 26, 2020. 2. Conducted an extensive background check producing, among other information, Mr. Sawinski's previous addresses, phone numbers, job history, social media accounts, car purchases, criminal history, relatives, etc. 3. Reviewed all of the discovery produced by the state prior to Mr. Avery's 2007 trial, searching for any record of Mr. Sawinski's phone call to the Manitowoc County Sheriff's Office. Footnote: Mr. Avery's expert determined that the internet on the Dassey Yonda computer was accessed on October 31, 2005, when only Bobby was home at 6:05 a.m., 6:28 a.m., 6:31 a.m., 7 a.m., 9:33 a.m., 10:09 a.m., 1:08 p.m., and 1:51 p.m. 4. Searched and corroborated Mr. Sawinski's statements based on other evidence, including but not limited to the affidavits of Blaine Dassey and Kevin Romlow. 5. Hired an additional licensed investigator, James R. Kirby, to conduct an additional background check of Mr. Sawinski through additional databases. 6. After confirming the veracity of Mr. Sawinski by its extensive investigation, Mr. Avery's counsel and staff conducted a telephone interview with Mr. Sawinski on April 9, 2021, related to what he claimed to witness. 7. After this interview, Mr. Avery's counsel and staff prepared an affidavit and requested Investigator Kirby to meet with Mr. Sawinski in person and conduct a second interview of him to determine his credibility. After thoroughly interviewing Mr. Sawinski and reviewing his affidavit with him for any changes, Mr. Sawinski executed his affidavit on April 10, 2021. Based on the foregoing, the notion that Mr. Avery's counsel did not reasonably investigate Mr. Sawinski and the information he has provided is simply untrue. Undersigned counsel and her investigator have had the opportunity to assess Mr. Sawinski's credibility based on his demeanor and the consistency between his observations and other known facts related to the disappearance of Teresa Halbach. Undersigned counsel's investigation into Mr. Sawinski and his affidavit have continued since the filing of the motion to remand, the results of which to date have only confirmed the credibility of the information he has provided. The state's reasonable investigation argument, which reasonably can be construed as an attempt to unreasonably divert this court's attention from the materiality of the information provided by Mr. Sawinski, is based on a misleading characterization of Wisconsin statute blah blah. The state's response suggests that an attorney must detail the steps Mr. Avery's counsel took to verify the truthfulness of assertions made in the pleading itself. Wisconsin statute blah blah imposes no such obligation. On the contrary, requiring an attorney to disclose such information would infringe upon the work product privilege. Most materials, information, mental impressions, and strategies collected and adopted by a lawyer after retainer in preparation of litigation and relevant to the possible issues must be initially classified as a work product of the lawyer, not subject to inspection or discovery unless good cause for discovery is shown. The state's argument that Mr. Avery's counsel did not reasonably investigate Mr. Sawinski and the statements in his affidavit because a new open records request was not made is not only unsupported by precedent, but is illogical. Based on the information in Mr. Sawinski's affidavit, the state was constitutionally required to disclose Mr. Sawinski's phone call in the information he provided to law enforcement to the defense before Mr. Avery's trial. Footnote says, also contrary to the state's false claim, which Mr. Sawinski's affidavit states quite clearly, Mr. Sawinski did not receive any reward, nor did he seek to receive any award. Undersigned counsel has reviewed all of the discovery disclosed by the prosecution, including records of phone calls made to the Manitowoc County Sheriff's Office, and nowhere in the discovery does such a record exist of Mr. Sawinski's phone calls. The state provides no explanation as to why a record of Mr. Sawinski's call would be produced in response to an open records request now if evidence of the call was withheld in the first instance. Indeed, the non-disclosure of concealment of exculpatory information is the crux of a Brady violation. The state seems unaware that the Manitowoc County Sheriff's Department disclosed in 2018 that it no longer had the telephone calls from citizens to its non-emergency number. Lastly, the state's efforts to compare the situation to Belich is a complete non-starter. In Belich, the plaintiff alleged that the defendant, whom she had hired to replace the windows in her home, stole $60,000 in cash from her office. However, the homeowner was present when the defendant removed the window from her home and admitted that she did not observe any unusual bulge in the defendant's clothing to suggest that he had secreted away such a large amount of cash. It was also undisputed that although the plaintiff discovered the money missing 3 days after the windows were replaced, she did not report the cash as missing to either her husband or the sheriff for another month. The sheriff's office investigated the complaint and closed the investigation without referring the defendant for criminal prosecution. The circuit court granted summary judgment in favor of the defendant and further found that the lawsuit was frivolous, awarding attorney fees and costs to the defendant. In affirming the circuit court's award of sanctions under Wisconsin statute blah blah, this court noted that the plaintiff's attorney did not conduct any pre-filing investigation or post-filing discovery to confirm his client's allegations. This court also observed that a number of circumstances about the plaintiff's allegations, including the unlikelihood that she would leave so much money unattended in the presence of a stranger, the improbability of the defendant being able to walk out of the residence with $3,020 bills on his person, and the plaintiff's delay in reporting the cash as missing, did not pass the smell test, which should have triggered additional investigation by her attorney. This court held that given these warning bells, the plaintiff's attorney's failure to conduct any investigation beyond taking his own client's word for what occurred violated that statute number, blah, blah, blah. It is readily apparent why Belich is inapplicable. Unlike the plaintiff in Belich, as set forth herein, undersigned counsel has conducted a thorough investigation of the allegations in the motion for remand. Moreover, undersigned counsel is not relying on her client's rendition of events to support the allegations in the motion. Instead, she is relying on the assertions of an independent third party who has no stake in this litigation. Most importantly, unlike Belich, the state has not identified any undisputed evidence that sounds warning bells calling into question the veracity of Mr. Sawinski's averments. In short, Belich has no bearing on any issue presented by Mr. Avery's motion for remand. Likewise, it is readily apparent that the state has not shown the motion for remand to be based on frivolous allegations and or that the motion was filed in violation of statute blah blah. 2. Because the state disputes Mr. Thomas Sawinski's credibility, this cause must be remanded. In its response, the state is quick to cast judgment on Mr. Avery's new witness and the information he provided without producing any evidence and or arguing that any evidence rebuts anything attested to by Mr. Sawinski. However, besides Mr. Avery's counsel's verification of Mr. Sawinski's background and information he provided, the record itself supports the veracity of Mr. Sawinski's affidavit and corroborates his statements. Among other evidence discovered by Mr. Avery's counsel, Mr. Sawinski's affidavit is consistent with Kevin Romlow's affidavit that he spotted the RAV4 on Highway 147 east of Avery Salvage Yard on November 3 and 4. Additionally, Mr. Sawinski's affidavit is consistent with the affidavit of Bobby Dassey's own brother, Blaine Dassey, in which he attested that he saw Bobby in possession of and driving a bluish-green vehicle Blaine did not recognize from the Avery property onto Highway 147 around 3:30 to 3:40 p.m. on October 31, the day Teresa Halbach disappeared. All this aside, the state's criticism of the veracity of Mr. Sawinski's statements is inappropriate for this court to consider anyway. It is not for this court, but rather for the circuit court sitting as the trier of fact to weigh the evidence presented at trial. And then it's citing a different case and says, quote, due regard shall be given the opportunity of the trial court to judge the credibility of the witnesses, unquote. The state's response merely substantiates that a conflict concerning Mr. Sawinski's credibility demands the circuit court's intervention for credibility determination. 3. Mr. Avery's motion is proper. As the state's response acknowledges, the decision to remand is left to this court's discretion. In its response, the state makes unfounded accusations of Mr. Avery's counsel trying to delay Mr. Avery's appeal. The state should be reminded that this court previously granted 3 of the 4 motions Mr. Avery filed to remand and supplement his post-conviction motion. Like Mr. Avery's current motion, none of these were considered frivolous, nor, quote, filed for an improper purpose, unquote, as the state now argues. Therefore, the state's convoluted argument that Mr. Avery somehow does not have a right to file a motion to stay his appeal and remand his case does not have any merit. pursuant to Wisconsin statute blah blah, all grounds for relief available to a person must be raised in his or her original, supplemental, or amended motion. Mr. Sawinski's affidavit supports Mr. Avery's claim that the state has engaged in a pattern of withholding exculpatory and or impeaching evidence from the defense. In addressing a Brady claim, a court is required to assess the cumulative impact of all the suppressed evidence to determine its materiality. Mr. Avery submits that this court's reasoning in its February 27, 2019 remand order that, quote, due to this case's extensive history, there is a benefit to having existing claims developed or litigated while they are relatively fresh, rather than positioning the claims to be procedurally barred in a future proceeding, unquote, should apply here. Mr. Avery has brought this issue to the court's attention in a timely manner. That the information Mr. Sawinski provided was not discovered and investigated by Mr. Avery's counsel until the briefs were submitted in this appeal should not affect this court's decision whether to remand Mr. Avery's case. Mr. Avery does not want to waive this issue by not addressing it at this time. The appeal must be stayed and this issue must be remanded to the circuit court for proceedings that should include a hearing concerning the undisclosed phone call Mr. Sawinski made to the Manitowoc County Sheriff's Office. The undisclosed phone call and information Mr. Sawinski provided to the Manitowoc County Sheriff's Office is exculpatory and or impeaching evidence which contradicts the state's primary witness, Bobby Dassey, testimony and inculpates Bobby Dassey as a third-party suspect pursuant to Denny. The state cannot credibly argue that Mr. Sawinski did not contact Manitowoc County Sheriff's Office with information related to seeing Bobby and another unidentified man pushing the RAV4 before the RAV4 was discovered on the Avery property on November 5th, 2005. The state's actions to demand that further proceedings be conducted to determine if Mr. Avery's due process rights have been violated under Brady. For the reasons above, this court should allow Mr. Avery's appeal to be stayed and remanded to the circuit court for further proceedings to determine whether Mr. Avery can supplement his motion to support his claim that the state violated his constitutional rights under Brady. Now we're only on page 13 of 56, so I hope you're all comfortable. But I'm going to guess it's just a lot of, here. Conclusion. Wherefore, undersigned counsel respectfully requests that this court enter an order staying this appeal and remanding this cause to the circuit court to permit Mr. Avery to pursue a supplemental post-conviction motion in connection with Mr. Avery's discovery of previously suppressed evidence by the state, dated this 22nd day of April 2021. Respectfully submitted, Kathleen T. Zellner and Stephen G. Richards. Affidavit of Kathleen T. Zellner. Now comes your affiant, Kathleen T. Zellner, and under oath hereby states as follows. Your affiant is of legal majority and can truthfully and competently testify to the matters contained herein based upon my personal knowledge. The factual statements herein are true and correct to the best of your affiant's knowledge, information, and belief. Your affiant is of sound mind and is not taking any medication, nor has your affiant ingested any alcohol that would impair your affiant's memory of the facts stated in this affidavit. 2. Your affiant is the lead counsel for Stephen Avery in case number blah blah. 3. Your affiant states that on December 26, 2020 at 10:42 p.m., her law office received an email from an individual by the name of Thomas D. Sawinski. Mr. Sawinski's email is attached and incorporated herein as Exhibit 1. 4. Your affiant reviewed the email carefully and decided to conduct a thorough background investigation of Mr. Sawinski before contacting him. 5. Your affiant reviewed all materials related to the Avery case, including all prior discovery requests, witness affidavits, and interviews to determine if Mr. Sawinski could be determined as to be a credible witness. 6. Your affiant also reviewed all discovery requests that she had made since assuming the representation of Mr. Avery in 2016. Specifically, your affiant made the following request, quote, "Please provide a copy of the dispatcher log related to Manitowoc County Sheriff's Office case number blah blah, and or any document log that exists related to communications between Manitowoc County Sheriff's Office dispatch and law enforcement, as well as with any private citizens," unquote. Mr. Larry Ledbina, Deputy Inspector of the Manitowoc County Sheriff's Office, responded, quote, and it's in bold, "We do not have recordings from that time period," unquote. And then it says in parentheses, emphasis added. Your affiant realized that any phone call from Mr. Sawinski to the Manitowoc County Sheriff's Office had been destroyed. This request and the response are attached and incorporated herein, Group Exhibit 2. 7. Your affiant's law firm conducted an investigation of Mr. Sawinski, which included gathering information about the following: his date of birth, relatives, employment history, telephone numbers, email addresses, possible criminal record, possible civil record, and car ownership. 8. Your affiant's law firm confirmed that Mr. Sawinski had worked at the Manitowoc Herald-Times during the relevant time period. Financial documents dating 2005 to 2006, as well as newspaper articles from 2005 to 2006, listing Mr. Sawinski as a paper carrier of the Manitowoc Herald-Times, are attached and incorporated here too as Group Exhibit 3. 9. Your affiant's law firm confirmed that Mr. Sawinski emailed the Innocence Project on January 7, 2016, regarding his witness observations. Attached and incorporated herein as Exhibit 4 is a copy of the relevant email. Your affiant confirmed that Mr. Dean Strang, Mr. Avery's prior attorney, did not have an email from Thomas D. Sawinski, but he could not confirm whether Mr. Buting had received an email because when Mr. Buting switched email servers, some of his prior emails had been inadvertently deleted. 10. On April 1st, 2021, a request was made to your affiant's, I don't know how to say that word, investigators, Edward R. Kirby and Associates, that a further investigation be done on Thomas D. Sawinski as delineated in the affidavit of James R. Kirby. 11. On April 9th, 2021, your affiant's law firm conducted an interview of Mr. Sawinski by telephone and prepared an affidavit reflecting the interview. Mr. Sawinski was visiting relatives in Manitowoc County. 12. On April 10th, 2021, James R. Kirby drove to Manitowoc County to interview Mr. Sawinski and review the accuracy of his affidavit, which was based on his telephone interview conducted by your affiant's law firm. Mr. Sawinski executed the affidavit, which was notarized by Mr. Kirby. Mr. Sawinski's affidavit is attached and incorporated herein as Exhibit 5. 13. On April 12th, 2021, your affiant's law firm filed defendant appellant's motion to stay, appeal, and remand the cause for Mr. Avery to supplement his post-conviction motion with a new witness affidavit establishing a Brady violation and a third-party Denny suspect. 14. Mr. Sawinski confirmed on April 21st, 2021, and today's the 22nd, right? With your affiant that he did not know of any reward money being offered, and that if money were given to him, he would donate it to the Halbach family. Mr. Sawinski's, that actually got me a little bit. Sorry. I don't know why that made me emotional, but it did. Mr. Sawinski's text message is attached and incorporated hereto as Exhibit 6. 15. Your affiant and her law firm hold the opinion that Mr. Sawinski is a credible witness based upon the extensive investigation your affiant conducted as described above and in the affidavit of James R. Kirby. Further affiant saith not. Signed by Kathleen Zellner, subscribed and sworn before me this 22nd day of April 2021. This is the email from Thomas Sawinski to Stephen Avery Lawyers. Just finished, and this is dated Saturday, December 26, 2020 at 10:42 p.m. So this is to Kathleen. Just finished second season. I lived there at the time. I was a motor route driver that was on the property every day to deliver newspapers. A few days before they found the RAV, I was delivering papers at about 1 to 2 a.m. and saw Bobby Dassey and another old man pushing the RAV down the road towards the junkyard. No lights at all. I almost hit them. They were very spooked. As you know, it's a dead-end street. After delivery paper, I had to go right back past them. Dassey stood in the road next to the RAV trying to stop me from getting by. As I approached, my headlights were on them 100%. Other guy hid behind open passenger door that was open from pushing the vehicle. I didn't slow down and drove in the ditch to get by, waving as I said, "Paperboy, gotta go." Dassey had no shirt on, and the other guy had a very scraggly beard and seemed to be in his 60s. I did call police, and they said they would contact me. They never did. After season 1, I emailed an attorney of... Sorry. I have to find where it was. I emailed an attorney of Stevens and no response. I've decided to reach out one more time as this information seems vital, especially after what I just watched. I live in Denver now, but lived in Manitowoc for over 20 years. So that's Exhibit 1. Next thing says, please provide a copy of the dispatcher log related to Manitowoc County Sheriff's Office case, blah, blah, and or any document log that exists related to communications between Manitowoc County Sheriff's Office dispatch and law enforcement, as well as any private citizens. Next is another email, subject forward request from Kay Hall to Kirby Investigations on Wednesday, February 1, 2017. Oh, that's what the above was that I just read. And now this is from Larry Ledvina on February 1, 2017. That says, I have received your request for recordings of calls from November 3, 2005. We do not have recordings from that time period. For any document request, be specific on what, and then it's got in quotes, documents and cases you are requesting. Thank you. Larry Ledvina, Deputy Inspector of Manitowoc County Sheriff's Department. Next thing is from the newspaper dated Sunday, October 15th, 2006. And it says, "Thank you, carriers." And then it's got pictures of several different people. And it says, "The rest of the newspaper carrier force." And then it's listing a whole bunch of people's names. And let me go to Thomas Sawinski's name is in there, where it's just listing all the people that deliver their paper. His picture isn't one of those pictures, though. This one is dated Saturday, October 15th, 2005. "Thank you to all Herald Times reporters and Lakeshore Chronicle carriers." So it's another picture and listing a whole bunch of people's names, to which, as I scroll down to the S's, there's a Thomas Sawinski there. There's also another Sawinski. Next one, case summary. Filed 10/1/2005, terminated 2/6/2006, discharged 2/5/2006. Disposition, standard discharge. So this is some debt. Thomas Sawinski filed for bankruptcy, so this is a bankruptcy report. We don't need to read through that. Not our business. And now this says State of Wisconsin versus Stephen A. Avery. I am of legal. So this is his affidavit again that we've already read before. So I'm not going to read through it again. That's the affidavit of Thomas Sawinski. Next one is where he had drawn on a Google map. See where the black dot is? That's where he said he saw Bobby Dassey and somebody else. So this road here is 147. And then that's, so, so it's shortly off of 147 where he saw Bobby down here. Because here's the salvage yard. Next thing says, "I just wanted to let you know that I never heard of any 100K reward until after this just all recently came out. Of course, money is nice, but this was never about a reward. I never knew of a reward, and if the 100K ever happens to get released to me, I would like it all donated to the Halbach family. I don't like my integrity being questioned. Feel free to make this public. Thomas Sawinski." Next is the affidavit of James R. Kirby. I don't need to read all the beginning stuff. Oh, he's located in Elmhurst. That's by me. Requested that he do this background check. And blah, 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 blah. Was notified by Ms. Zellner's office that they had made telephone contact with Mr. Sawinski on April 8, 2021, and that he was visiting his family in Manitowoc and was willing to speak with Ms. Zellner directly. It is your affiant's understanding that Ms. Zellner and her staff interviewed Mr. Sawinski on April 9, 2021, and prepared an affidavit from that interview. Ms. Zellner requested that your affiant do an in-person interview on Mr. Sawinski on April 10, 2021, and review the affidavit that had been prepared as a result of Mr. Sawinski's interview with Ms. Zellner and her staff. Your affiant drove to Manitowoc on April 10th and met with Mr. Sawinski, who reviewed the affidavit and felt confident that the encounter occurred on a Saturday because his normal routine was to deliver papers very early on Saturdays. It was very startling to Mr. Sawinski to see someone on Avery Road that early in the morning. Your affiant has interviewed over 10,000 individuals throughout the course of his career. In reviewing the affidavit with Mr. Sawinski, your affiant found him to be credible because of his demeanor, and his affidavit was supported in part by the investigation that your affiant did of Mr. Sawinski. Furthermore, Mr. Sawinski's story is supported by information that your affiant had obtained from his investigation from other witnesses regarding Bobby Dassey and the vehicle. From speaking to Mr. Sawinski, your affiant observed that Mr. Sawinski displayed no knowledge or expectation of a reward during your affiant's interview with him. Currently, your affiant is investigating Mr. Sawinski's description of a second individual that he observed with Bobby Dassey as detailed in Mr. Sawinski's affidavit. So, and that 21st of April is when that was sworn. Next one, affidavit of Kevin Romlow. It's all the beginning stuff. In 2005, I lived near Mishigat, Wisconsin. I am familiar with the Todek family because I am acquaintances with Sean Todek. Sean's brother Scott is now married to Stephen Avery's sister, Barb. On November 3 and 4, 2005, I was in Mishigat. I saw Teresa Halbach's vehicle by the East Twin River Dam in Mishigat at the turnabout the bridge as I drove west on Highway 147. Around midday on November 4, 2005, I stopped at the Senex station at the intersection of Highway 147 and State Street in Mishigat. While there, I saw and read a missing person poster for Teresa Halbach. I remember that the poster had a picture of Teresa Halbach and written descriptions of Teresa Halbach and the car she was driving. I recognized the poster attached as Exhibit A to this affidavit as a copy of the one I saw at the Senex station on November 4, 2005. I recognized that the written description of the vehicle on the poster matched the car I saw at the turnaround at the dam. While I was at the Senex station, a Manitowoc County Sheriff's Department officer came into the station. I immediately told the officer that I had seen a car that matched the description of the car on Teresa Halbach's missing person poster at the turnaround by the dam. In December 2016, I watched Making a Murderer. In the series, I recognized the officer who I talked to at the Senex station on November 4, 2005. A photograph of this officer is attached as Exhibit B to this affidavit. Having watched Making a Murderer, I now know that his name is Andrew Colborn. After I watched Making a Murderer, I sent a text message to Scott Todek. Having reviewed a saved copy of that message, I know that I sent it on December 12, 2016 at 6:13 p.m. In the message, I told Scott Todek that I had seen Teresa Halbach's car in Mishigat on November 4, 2005, and had told the officer in the Senex station. On December 19, 2016, I sent Scott Todek another message. I never heard back from Scott Todek. Copies of the text message conversation I had with Scott Todek are attached as Exhibit C to this affidavit. Nothing has been promised or given to me in exchange for this affidavit. And this was sworn on the 15th of July in 2017 from Kevin Romlow. So then it shows the picture of the missing poster of Teresa that he saw. That shows the picture of the car. And then next is the picture of Colborne. And here's the text message to Scott. I just watched the series Making of a Murderer, and I gotta tell ya, I need to get in touch with one of their lawyers, as Colborne I saw at Cenex and told him that vehicle was at the old dam on a Thursday or Friday. And I'm guessing November 3rd was the day he called the plates in. No response from Scott. December 12th, hey, give me a call, and his phone number. And Scott responds with, okay, I will. I am really sick. Now can. And that's all it said. Here's the affidavit of Blaine Dassey. In October 2005, I lived with my mother and brothers at blah, blah, blah. My brothers' names are Brendan, Brian, and Bobby Dassey. Brendan and I shared a bedroom. Bobby had his own bedroom. Brian kept some clothes at the house, but lived with his girlfriend and was rarely at the residence. Tom Yanda had moved out of the residence in early 2005. When none of us were home, the residence was always locked. My uncle Stephen Avery only came to the residence when my mother and his sister Barb was home. I never remember my uncle Stephen entering the residence when my mother was not home. I remember that my uncle Stephen had cut his finger 1 to 2 weeks before October 31, 2005. I remember on October 31, 2005, seeing my Uncle Stephen carrying a white plastic bag to his burn barrel. I did not see a fire in the burn barrel. However, the police pressured me into saying that there was a fire in the burn barrel and visible smoke coming from the burn barrel. My testimony about the fire and smoke coming from the burn barrel was not true. I remember on October 31, 2005, seeing a bonfire behind my Uncle Stephen's garage that was about 3 feet high. The police tried to pressure me into saying that the flames of the bonfire were much higher. So at trial, I testified that the flames of the bonfire were 4 to 5 feet high, but that testimony was not true. The police put the height of the flames, quote, in my head, and I agreed to it, unquote. On October 31, 2005, I was with Brendan up until I left to go trick-or-treating. I distinctly remember Brendan wanted to use the computer at slightly before 5 p.m. because I wanted to make a phone call, and his use of the dial-up internet computer would have prevented me from doing that. I know that Brendan was not at Uncle Stephen's trailer up until I left to go trick-or-treating. There was only one computer at the residence, and it was always in Bobby's room, sitting near a desk. The computer had a password. The computer had an AOL dial-up internet connection. Bobby was the primary user of the computer. At no time did I ever do searches for pornographic images or words related to pornography, words related to violence, words related to death, words related to mutilations, words related to torture, words related to guns or knives, words related to Teresa Halbach, words related to Stephen Avery, words related to DNA, or words related to dead, mutilated, or dismembered female bodies. At no time did I ever create a folder for Teresa Halbach, my Uncle Stephen, DNA, or news stories on the murder. The only time I used the computer was to do my homework and occasionally send instant messages. I remember my mother Barb hiring someone to, quote, reformat the computer, unquote, but I'm not sure who that person was. I do not have any personal knowledge of who made the appointment with AutoTrader to have my mother's van photographed, but I did help clean the van so that it could be sold. At the time, my family had 2 burn barrels located behind our house. I was familiar with the gravel pits to the south of the Avery salvage yard, but I did not go to the gravel pits to hunt. I stopped hunting when I was 22. On October 31, 2005, when the school bus driver brought Brendan and me home as we traveled west on State Highway 147, I saw Bobby on State Highway 147 in a bluish or greenish vehicle heading towards Mishicot. Bobby was not driving his black Blazer. Bobby was not home the rest of the evening while I was home. Attached and incorporated herein is Exhibit A, is a map that of the location of Bobby's vehicle that I described in this paragraph. This is dated 25th day of June 2018. All right, so in his map, all right, so 147, Avery Road here. This is where Bobby was. Going towards where you would go to Cuss Road. So Bobby here. So Bobby's going the direction towards Cuss Road, where you would go to Cuss Road, and the bus was going to Avery Road. And so now this page says Stephen Avery by counsel moves the court to stay this appeal pending disposition of a motion filed in the circuit court on August 26, 2016, seeking post-conviction scientific testing of evidence. The state does not object to the stay request and suggests remanding the record to the circuit court pursuant to Wisconsin statute blah blah for the court's use in determining the pending motion and any subsequent motion based on the results of further testing, if any, authorized by the circuit court. A stay of this appeal and remand of the record are appropriate. Avery also moves the court to substitute attorney. Oh, this is old. Don't need to read that. I'm scrolling to see if there's anything else that we should be reading other than these. These are the these are the other times when he's asked for the stay and remand. Okay, so that's everything. Down to the bottom. So if you want to read that for yourself, that's on Kathleen's website, KathleenTZellner.com. Then you can go on the right, you would go to cases, and then she's got highly publicized cases. Stephen Avery is the first one. You click there. It'll bring you to the Stephen Avery page, and the very top thing is the link for all of this. Also on there, you can read the prior filing she's done. She's got a whole bunch of stuff there. Also on her website, if you wanted to donate to Stephen's commissary or to Kathleen, she's got the links in there. Summary, please. Summary is that the state wants the court to, who cares about this, claiming that this guy, the new witness, has not been vetted. So this is Kathleen doing the booyah. He's been vetted so much and way more than they vetted Bobby as being their star witness. And it is Bobby's testimony alone that they rely on saying that Teresa Halbach never left Avery Salvage. because Bobby claims he saw her there taking pictures, and then when he left, her car was still there, but she was gone. He didn't see her. So from that, they go with Teresa Halbach never left, and whatever happened to her was done by Stephen. But we know over and over Bobby has lied. His mother, Barb Tadek, even posted on Facebook that she asked Bobby, and Bobby said he saw Teresa leave. Bobby's buddy, Scott Tadek, when you listen to that phone call, that you can hear clips of it if you go to Brad Dassey's Facebook or his YouTube. He has a new song that he's got due to Barb coming after Brad. He's got excerpts from that phone call in there where you can hear Scott in a phone call between Scott and Barb and Steven, where Scott says, I was never even on that smurfing property that day. So Scott is saying that he had seen a fire, and then he saw Brendan by the fire and blah, blah, blah. But then on the phone with Steven, he's saying he was never even on that property that day. The state inferred that this guy has only come forward for the reward. And we know now the guy didn't know anything about the reward. How many of you people even know about the reward? People who are on Stephen Avery Project, our public page, y'all don't follow the case as in depth as a lot of the people do. So like the people in our closed group, MAM Gossip, they know about the reward. I'm sure a lot of them. It's been talked about, but I'm sure many of you don't know about the reward and don't know what I'm talking about. So how do you know that guy would know a reward has been offered? Plus, that reward is, to me, I've said, it's impossible to get because it says the real killer must be found guilty and go to prison. So just giving information isn't enough to give you the reward. So, it's hard to get that money. But this guy states he didn't know about the reward, and if he were to get it, he would want it to go to the Halbach family. Hold on a second. Mickey! My dog's getting in trouble in the other room, and I could hear it. Yeah, knock it off. So this guy doesn't like that his integrity is being challenged for nothing. So if there were to be a reward come his way, he would donate it to the Halbach family, and it choked me up. I mean, of course, I would prefer the money go to Dolores Avery's care. But I understand why somebody would want it to go to the Halbach family, and I don't have an issue with that. Blaine's statement is not new. We've known this for a while. It came out in a prior filing. But she's including that in this because it's further people that are showing that Bobby is a liar. Bobby. His own brother saw Bobby driving that car that day. So, his own brother said it. Brian Dassey, now she mentioned something about it in that. There was no affidavit from Brian Dassey, but and you can, if you want to go down this rabbit hole yourself and read all this information for yourself, you go to StephenAveryCase.org. That's where you can find all the transcripts, recordings, all this stuff to do your own investigating. You don't need to take it from me on what I say something. Go look at the evidence yourself. But you would be able to find it there when Brian Dassey was interrogated. He said that his brother Bobby told him he saw Teresa Halbach leave that day. So Brian says Bobby saw him, told him that he saw her leave. Blaine saw him driving Teresa Halbach's vehicle that day. Barb has posted in her Facebook fan group that she asked Bobby, and Bobby said he saw Teresa Halbach leave that day. Bobby says he never saw her leave that day when he talks to law enforcement. Blaine says in his affidavit that the computer was always in Bobby's room. Bobby was the one to always use it. They had internet. And that Bobby did not look up any of, or that Blaine did not look up any of that disgusting stuff. At the time that those disgusting things were being looked up on the computer, the only one home is Bobby Dassey. Everybody else is at work or school. Bobby works the night shift and comes home at 6 a.m. Barb desperately tries to act like they didn't have internet. Barb tried to have somebody wipe that computer. Barb asked her now former stepson, Brad Dassey, who worked on computers at the time for a living, if reformatting a computer would wipe everything out of the computer. Brad told police about it right away. And now this week, Barb files harassment charges against Brad. They had internet. Computer was in Bobby's room. Barb says it wasn't in Bobby's room. Carla says it's not Bobby's computer. Carla says Steven could have gone in there and looked up the porn. Nice family members who think they're running a support page for Steven. But according to Blaine, the house is always locked when people aren't home, and he's never seen Steven go over there if Barb's not home. And that the computer was in Bobby's room. And when you look at the pictures from law enforcement, when they took of the house, when they went in there, computer was in Bobby's room. And I believe you also see it in Making a Murderer when they show the picture. Bobby's own brothers have shown that Bobby is lying. This witness knows that he was there on Saturday and somewhere between 1 and 2 in the morning because he would go early to deliver his papers on Saturdays, which is understandable. You want the weekend for whatever, so you go early. So he knows it's about 1 or 2 a.m., dark. Pulls in, so he was turning left from 147 onto Avery Road. When you see from his map, it wasn't that far that he had been on Avery Road, then all of a sudden there they are. And I don't know how he drives. I know how I drive. And if I'm out on that, because 147 is just a 2-lane road, it's farms and everything all around. I'd be driving pretty fast, probably. And then you're going to make that left, because you're not stopping to make the left because there's no other traffic out at that time. So you don't need to slow down or whatever. So you could be going at a pretty, fast clip that you turn there and all of a sudden in your headlights you're seeing a car. That would scare the smurf out of me. And so then he goes around them and continues down Avery Road, and then you got to turn right to go to the mailboxes there, put the paper in the mailboxes, turn around and comes back. And when he's coming back, Bobby Dassey, who's on the driver's side outside of the car as they're pushing it, steps into the road further to try and block him from continuing. So he has to go around by going into a ditch, which I know, okay, Carla, Stephen's niece, who wants to call herself the family spokesperson and does everything she can to try and keep Stephen in prison, is going, there's no ditch. Yeah, he means he had to go off the gravel road into the side, into the grass there, and get around. All right. Why is it that they try to be as technical as possible in defending Bobby, but not in showing that Stephen and Brendan are innocent? It drives me crazy that these are his family, who like to be on Facebook and Twitter of, I'm the family spokesperson and look at us, send us money, look at our GoFundMes. So Thomas Sawinski sees Bobby Dassey and some unknown older man. 2 a.m. Calls Manitowoc County Sheriff's Department. Talks to a woman who says, yeah, we know who did it. Nobody calls him back. He watches Making a Murderer, reaches out to Strang and Buting. Nobody gets back to him. And then he watches Making a Murderer Part 2 just a few months ago and decides he's going to reach out one last time because he thinks what he saw is very important to this case. And Kathleen Zellner is the only one that took him seriously. And something the state said in trying to get this, dismissed, that Kathleen hasn't done her due diligence. It's all been shown that she did in looking into Mr. Sawinski, and that he is a credible witness. It's so infuriating, isn't it? And yeah, I know this goes back down to Judge Flowers. I fully expect her to deny it. I don't expect much out of these people to look for real justice, to care about who really did something to Teresa Halbach. They just wanted Stephen Avery to go away because he was going to get $36 million. $2 million for every year they put him in prison for an assault he didn't do. Thank you to Thomas Sawinski for trying a third time. And I know how hard that is to come forward when a lot of the Avery family will come after you now and will have their minions try to discredit you. Anything to protect Bobby. Don't care about showing that Stephen is innocent. lot of people aren't going to believe him. Where's the proof? I don't. What does he have to gain from coming forward? It's more headache than anything else. So I want to thank him for coming forward. I thank Blaine and Brian Dassey. Barb is their mother. I know the things that they've said, isn't recent, but still thank them. Thank you to Brad Dassey. It's hard to do what they have all done. Just hoping, at the very least, that we can get a new trial for Stephen. They should just open the doors and let him out. If the state is so worried about wasting time and money, great. Let's not try him again. Just let him go free. Let him go home. Problem solved. But at the very least, he should get a new trial. He did not get a fair trial. I'm not even going to start going down that rabbit hole of how he didn't get a fair trial by starting with the plants that were on his jury. Of the people who worked for Manitowoc County Sheriff's Department that were on his jury. Hi, Bradley. Kathleen's not going to quit. It just takes a lot of time, a lot of years to free somebody who's falsely convicted. Just got to hang in there. And yeah, it has been really crazy since she made this first filing that the Avery family is like having a complete meltdown. Why are you having a meltdown right now? When this should be good. You should be happy that these things are coming out to help Stephen. But instead, Barb files harassment charges against Brad, and Kayla files them against Stephen. Curiouser and curiouser. Alright, so I'm going to call a close to this live. I don't know, maybe I'll swing back over into our closed group, MAM Gossip. Oh, I don't know if I want to go through reading all this today and maybe just do it tomorrow instead. Because I've already done a live in there today that I was live in MAM Gossip earlier for an hour and a half. Because we just got the information on Kayla filing the harassment charges against Stephen. So, I don't know. I'm undecided if I'm going live in MAM Gossip today or tomorrow. So, other than that, the next time I'm scheduled to go live, if you're interested, starting on Monday in our closed group MAM Gossip, we're gonna start watching Making a Murderer together and commenting. So there's an event. One of our moderators, Christopher, made the event. So we'll be doing that Monday through Friday next week. So if you want to join us for that, we do those kinds of things in the gossip group because it's a closed group and easier for us to not have to deal with people who just want to spam on a public page. So, all right, I am out for the evening. Thank you everybody who joined us live and who is going to watch this later. We're going to keep fighting for Stephen's innocence. And thank you, Kathleen Zellner and her team. We'll talk soon. Investigation.